Sir, please continue.
Yeah. A very good morning to all the viewers and the webinar team. This is A. Ram Prasad, Principal, Telangana Model School, Ramachandrapuram, Sangareddy District. So while continuing the webinar sessions for intermediate first year as well as second year, I have the privilege to introduce Mrs. Shaitaz Begum, Postgraduate Teacher in Political Science from Telangana Model School, Dhanwada, Narayanpet, to conduct a session on state government for intermediate second year students. She has a vast experience in teaching for various levels, and she is associated with Telangana Model School since inception in 2013. She is a wonderful orator, and the students have already made use of her services earlier. I look forward for one more session from her on the topic state government for intermediate second year students. Over to Mr. Shaitaz Begum for her session.
Good morning, everyone. This is Mrs. Shaitaz, PGT, Political Science, Model School, Dhanwada, Narayanpet District. I am very happy to conduct this session for intermediate second year Political Science, continuation part of state government. In my previous session, I have already discussed state government, the powers of Chief Minister, Governor, and Council of Ministers. Like state government, how it is important and what are the different wings through which the state government administers and checks out its jurisdiction. As you can see here in the slide, the state government, it has three separate branches like state executive, you can see a state governor means state executive, state legislature, and state judiciary, that is court. So in this chapter, we are going to discuss thoroughly about the different aspects, different powers and functions of these branches of the government. Now let us recapitulate, let us recall what we have learned in our previous session, because that is very compulsory, because this is a continuation session. In our previous chapter, we have discussed that part 4 of Indian Constitution from articles 152 to 237 deal with the matters of state government. It contains the structure of various organs and powers and functions of state government. There are two executive heads in all the states, the governor and the chief minister. The governor is a nominal head and the chief minister is a real executive. The governor of all the states is appointed by the President of India and the chief minister is appointed by the governor of a particular state. So this is what we have learned, and we have also discussed the powers of governor, powers of chief minister, and the powers of state council of ministers, which form the state executive. So in short, in our previous session, we have discussed state executive. So in this session, we are going to discuss the state legislature and the state judiciary. So as you can see here in this flow chart, state executive, it comprises of governor, chief minister, and state council of ministers. State legislature, which we are going to learn in this session, it comprises of legislative council and legislative assembly. State judiciary, that is, it comprises of high court, district courts, and session courts or other courts. So first, let us discuss the importance of state government. Why are state governments important? India, it follows a policy of division of states, federal system. Each state in India has its own state government. Why? Because to administer and to conceive the concept of well-being of the people. State government, they are very important. Why are they important? They are important because they are responsible for the basic community infrastructure like law and order, local transports, health services, community development program, all such, conducting elections, giving laws related to marriage, divorce, issuing licenses, issuing other all important aspects in our daily life. So the state government is responsible for all these things in our life. The state government is a lower level of service provider, after the central government. The main service provider for us is the union government. As we follow a federal system, the powers are divided between the union government and the state governments. The state governments, in fact, take up a responsibility for the development of an individual and caters to the needs of the individual. They perform different functions, like they establish local governments at village levels, and they also issue licenses for marriage. They also issue licenses for driving, hunting. They also conduct elections. So there are many functions of the state government which are very important for us, which are very important for the administration of a country. So in this session, we are going to discuss the state legislature and the state judiciary. As you can see here in this flow chart, the state executive, the state legislature comprises of legislative assembly and legislative council. The state legislature comprises of three. What is that? Legislative assembly and legislative council headed by the governor. All these three, they comprise, and together they are called state legislature. Governor, legislative assembly and legislative council. These three comprise and they are called the state legislature. Now let us discuss one after the other briefly. Let us start with legislative assembly. Legislative assembly, which is also known as Vidhan Sabha. According to the Constitution of India, there will be a legislative assembly for every state. For every state, there will be compulsorily a legislative assembly. According to Article 168 of Indian Constitution, state legislature will consist of legislative assembly, legislative council, and the governor of the state. All these three together are called state legislature. Don't get confused, students. Listen carefully. I repeat. What is state legislature? It consists of three: legislative assembly, legislative council, and the governor of the state. These three together form the state legislature. Legislative assembly is an important organ of the state. It is an important organs of the state, and the members are directly elected by the voters. Members of legislative assembly are directly elected by the voters. Legislative assembly, what is the function of legislative assembly? It enacts laws. It makes laws for the administration of the state and particularly for the well-being and welfare of the people. That is the primary function of the legislative assembly, to enact laws. The legislative assembly is a lower or the first house having members who represent the people. The legislative assembly, it is the lower house or the first house of the assembly which represents the people. That means the members of legislative assembly are directly elected by the voters. We elect them directly. Now let us see the composition of legislative assembly. There will be a legislative assembly for every state. For every state, compulsorily we have a legislative assembly to frame laws or to enact laws. Legislative assembly, it represents the people of the state. Members whom we vote are there in the legislative assembly who speak on our behalf and who think about the well-being of the people. When we cast our vote, we send our representatives to the legislative assembly. So compulsorily, every state has a legislative assembly. How many members do we have in Legislative Assembly? It members varies between 60 to 500, maximum and minimum and maximum limits between 60 to 500. And this members, it depends upon the proportionate to the population of the state. That means if any state who has less population, members of the assembly will not be 500. So always the members of the Legislative Assembly will be proportionate to the population of the state. Now all states in India do not have the same population, isn't it? So that is why the members of different state assembly, also number of members for different state assembly also differs, because it is proportionate to the population of the state. And the percentage of seats in legislative assemblies are reserved for ST and SC, scheduled tribes and scheduled caste. How are these members elected? As I said you, members are elected directly by the voters of various constituencies of the state, by the members of the various constituencies of the state. Now, what is constituency? Each state is divided into territorial constituencies. Each state is divided into territorial constituencies, so that there should be an easy or flexibility in the administration. So the members are directly elected for various constituencies in the state by the people. Now let us see what are the qualifications to become MLA or to have a seat in the legislative assembly, member of legislative assembly. To become a member of legislative assembly, he or she must be a citizen of India, must have completed 25 years of age. Him or she must have completed 25 years of age and should pay 10,000 rupees as deposit. Should pay 10,000 rupees as deposit. To whom the contesting candidate should pay deposit? To the election commission. The election commission takes various steps to conduct the free and fair elections in the state and the country. So the deposit of this money is one among those steps. Why this deposit is taken? It is taken so that the candidates who are contesting, they should really contest and they should have the possibilities of winning. That means they should have some realistic chance of winning, and also to ensure seriousness when the candidates file their nominations, to ensure seriousness in the political system. So that is why this deposit is demanded from the contesting candidates by the election commission. The candidate must not hold an office of profit either in the state government and the central government. The candidate is barred from holding an office of profit. That means for financial benefits or any other benefits, the candidate should not hold an office of profit, because it put them to a position from wherein they gain some financial benefits. The candidate must possess other qualifications as prescribed by the Act of Parliament. There are different qualifications which are prescribed by Parliament. So the candidate should also match to those qualifications in order to contest for the elections for MLA. Now tenure, that means the duration. The tenure is 5 years. The tenure for Legislative Assembly is 5 years. It can be dissolved before the tenure ends. It can be dissolved by the governor at any time. Legislative Assembly, it is not a permanent house. So it can be dissolved by the governor at any time before the tenure ends. And it can be suspended or dissolved by the president under Article 356. The governor also has the powers to dissolve it, And the President of India has the power to suspend it or dissolve it under Article 356. Under Article 356, the President can completely dissolve. He can dissolve when a situation arises, when an emergency situation arises, and when he feels that the state cannot function now according to the constitutional norms. So in such conditions, the President can suspend or dissolve the legislative assembly, The Legislative Assembly may be extended for a period of 1 year. After that, the elections has to be conducted within 6 months. The Speaker and the Deputy Speaker. The Legislative Assembly will have 2 elected officers for conducting its business. The Speaker and the Deputy Speaker. For conducting the daily meetings, the Legislative Assembly will elect 2 people. Officials. They are called Speaker and the Deputy Speaker. The Legislative Assembly will hold its meeting at least twice a year, 2 sessions in a year, and there should not be a gap of more than 6 months between any 2 sessions of the Assembly. The present Telangana Legislative Assembly Speaker is Mr. P. Srinivas Reddy and Deputy Speaker is T. Padma Rao. So these 2 speakers, Speaker and the Deputy Speaker, they take up the responsibility of conducting the meetings of the House. They also maintain the decorum in the House, that is the discipline of the House. Next, quorum. What is this quorum? According to Article 189, the quorum for conducting the State Legislative Assembly meeting is fixed. That is 1/10 of the total membership. 1/10 of the total membership. What is this quorum? The minimum attendance required to conduct the meetings of the House. That is quorum. So what is the minimum attendance required? 1/10 of the total membership. And the Speaker of the Assembly has the power to adjourn the meeting when the particular or fixed quorum is not in the House. Now let us discuss the other important aspect, Telangana Legislative Assembly, Telangana Legislative Council. The Constitution of India provides a legislature for every state in Indian Union. It does not adhere to the principle of bicameralism in case of every state legislature. Bicameralism having 2 houses, that is Legislative Assembly and Legislative Council, that is bicameralism. It does not, the state Indian Constitution does not adhere to the principle of bicameralism. At present in India, there are only 6 states which follow bicameralism. That means which have both the houses in the state legislature. That is Legislative Assembly and also Legislative Council. And these 6 states who have bicameralism are Telangana, Andhra Pradesh, Bihar, Karnataka, Maharashtra, and Uttar Pradesh. These are the 6 states of India which follow bicameralism. That means which have both the houses, Legislative Assembly and Legislative Council in the state legislature. The remaining states are unicameral. That means they have only Legislative Assembly. They do not have Legislative Council. Compulsorily, Legislative Assembly should be there. There's no option of not having it. Only thing we can abolish is Legislative Council. And according to Article 169, it provides for the special provision for the creation and abolition of Legislative Council. And the Parliament is empowered to create a Legislative Council for a state which has no Legislative Council. The state which has can also go for abolishing the Legislative Council, and the state who does not have Legislative Council can opt for making or creating Legislative Council from the permission granted by Parliament. Legislative Council, which is also Vidhan Parishad, it is the upper house of the state legislature, upper house of the state legislature, and it is a permanent house. The total membership of the Legislative Council normally cannot be less than 40 and cannot be more than 1/3 of the total membership of the Legislative Assembly of the state. So the membership of Legislative Council merely depends upon the total membership of the Legislative Assembly of that particular state. It should not be more than 1/3 of the total membership. What are the qualifications required to become MLC? It should be a citizen of India, member of Legislative Council, MLC. He or she must be a citizen of India, must have completed 30 years of age, should possess other qualifications as prescribed by the Parliament. Should possess other qualifications as prescribed by the Parliament. Must compulsory be a registered voter. The Legislative Council is a permanent house. It is a permanent house, so it cannot be dissolved or it can neither be suspended by anyone. It remains same. It is a permanent house. The Legislative Council, all members are not elected at a time. They are not elected at a time and neither they retire at the same time. The Legislative Assembly also meets at least twice a year and there shall not be a gap of more than 6 months between each sessions. The membership, the term of members for Legislative Council is 6 years. And 1/3 of its members retire after every 2 years. Composition of Legislative Council. Let us see how members are differently represented in the Legislative Council. There are 5 different categories of representation in the Legislative Council. There are 5 different categories of representation in the Legislative Council. As you can see here in this slide, the first representation is from graduates. 1/12 of the total membership is elected by an electorate of graduates or university graduates or others possessing the same or equivalent qualification. Next, 1/12 to be elected by an electorate of teachers or those in higher institutions. Then nearly 1/3 of the members are to be elected by local authorities. What do you mean by local authorities? Local authorities means local self-governing bodies like municipalities, municipal corporations, MPTC and ZPTC, members of MPTC and ZPTC in the particular state. Nearly 1/3 members are elected by the Legislative Assembly members of Legislative Assembly. Then the remaining 1/6 members to the Legislative Council are nominated by the governor of the particular state. Then on what basis these are nominated? What are the prerequisites required for these? The governor nominates them on basis of some special knowledge in or practical experience in literature, social service, science or arts. All these are prerequisites to be nominated by the governor. So the remaining 1/6 are nominated by the governor based on these prerequisites. The members are elected. How are they elected? They are elected by the method of proportional representation by means of single transferable vote. They are elected by the method of single transferable vote. Single transferable vote is also called choice voting. It is also called choice voting. Why it is called choice voting? Because it is a ranked system. It is a ranked system in which voters rank candidate in the order of preferences. Voters, they rank the candidate in the order of preferences. Like it is an electoral system, single transferable vote. It is an electoral system in which the person vote can be transferred to a second or the next competing candidate, to the next competing candidate. The Legislative Council has a chairman and a deputy chairman for the conduct of meetings. The Legislative Council also has a chairman and a deputy chairman for the conduct of meetings. In their absence, vice chairman also conduct the meetings. They are elected by the members of Legislative Council. How are they elected? They are elected by the members of Legislative Council among them. Now let us state legislature. Let us discuss powers and functions of state legislature. You can see we have different functions of powers, participation in constitutional amendment procedure, electoral functions, and other functions. These are the 6 different functions which the state legislature performs to take care of the administration of the state. Let us discuss briefly. First, legislative powers. Legislative powers, that means to make laws. The primary function of the legislature of a state, or also that is in the parliament, it is to make laws. To make laws on the subjects of state and concurrent list. The state legislature, it makes laws on the subjects of state and concurrent list. Now, what do you mean by state and concurrent list? The legislative system or the legislative section is divided into 3: union list, state list, and concurrent list. Union list, state list, and concurrent list. What are state list? State, according to the 7th schedule of Indian Constitution, the state list has 66 items included in it. That means the state governments are empowered to make laws on these subjects. Only the state governments are entitled. And these subjects among the 62 items are public order, maintaining law and order, health and sanitation, managing hospitals and dispensaries, that is public health services, etc. These are some of the items which are mentioned in the state list. Ordinary bills can be introduced in either of the 2 houses. Ordinary bills, we have 2 kinds of bills, ordinary bills and money bills. Ordinary bills, they pertain to the non-economic and administrative affairs of the state. The bills pertaining to the non-economic and administrative affairs of the state are called ordinary bills. Ordinary bills, they can be introduced in any of the houses, like either in Legislative Assembly or in Legislative Council. But almost all the bills are introduced first in Legislative Assembly and sent to Legislative Council for approval. These bills, they become laws when they are passed by both the houses and assented by the governor. Both the houses, after a thorough discussion on the bill, they are passed to the governor for assent. First, the bill is introduced in the Legislative Assembly. Then, after a thorough discussion, it is passed to Legislative Council for approval. Then, after that, if the Legislative Council also approves the bill, it is passed to the governor for assent, that is for his approval. The Legislative Council can delay the bill for maximum of 4 months. The Legislative Council can delay the passing of the bill for maximum of 4 months. After that particular period of time, it is deemed that the bill is approved by the council, and then it is declared that the state legislature has approved the bill. So only 4 months time is there with the legislative council to give their assent or consent. So when the legislative council, when the bill is forwarded to the legislative council for its approval from legislative assembly, there are 4 stages. There are 4 stages which the legislative council adopts. The first, when the bill is passed from the legislative assembly, in the legislative council, the speaker introduces the bill to the legislative council. The first option is it may reject the bill. It may directly reject the bill. Second possibility, it may change some or all contents of the bill. The legislative council, it can change or some or complete contents of the bill. Third possibility, third option, the legislative council may take no action on the bill for a period of 3 months. They may just discuss, but they may not come to a conclusion. That is, they may not take any action on the bill. That is a third possibility. And fourth, it may pass the bill to the legislative assembly again for reconsideration. So when this fourth one, that is when the bill is again passed to the legislative assembly for reconsideration, then the assembly may accept the bill, again negotiate the discussion with the changes which have come or forwarded from legislative council. The assembly may accept the changes or deny the changes, and then after a period of 4 months, the bill is passed after the consent of the governor. The bill is sent to the consent of the governor, and in this lawmaking matter, the legislative assembly takes an upper hand when we compare it to legislative council. After a stipulated period, the bill is deemed to be declared after getting the consent from the governor. The next important powers are executive powers and financial powers. The state legislature exercises control over the state council of ministers headed by the chief minister. The state executive, what is the state executive, students? In my earlier session, I have discussed the chief minister and the state council of ministers. They perform the state executive. These ministers, they are directly responsible for legislative assembly for their acts. Each minister is in charge of a different department. So that particular minister is answerable for his department. The legislatures exercise control over ministry. The legislative assembly minister, they exercise control over them, like some constitutional methods, using some constitutional methods like call attention motions, adjournment motions, questions, or no confidence motions. These are some constitutional methods which can be used by the legislatures to exercise control over the ministry. What is call attention motion? Call attention motion in which the minister, with prior permission from the speaker of that house, takes and asks questions to a minister which requires public attention or which is a matter of urgent concern, which is public importance matter. So in this, they give their discussions. That is called attention motion. What is adjournment? Adjournment is again drawing attention of a minister to attend the immediate matter of some public importance. That is adjournment. No confidence motion is passed by a majority number of voters when an individual is deemed to be fit no longer and who is not performing his duty well. So in such situations, no confidence motion is passed. Financial powers. What are the financial powers of state legislature? The state legislature exercises control over the finances of the state government. The legislative assembly first approves all the money bills and later the council approves them. First, the money bills are discussed in the legislative assembly and then forwarded to the council for approval. If the council fails to approve the bill within the stipulated time, then the bills are deemed to be approved by the state legislature. There is a particular time, stipulated time is 4 months. Within 4 months, the bills has to be given consent by the legislative council. If the stipulated time is crossed, then the bills are deemed to be approved by the complete state legislature after taking consent from the governor of the state. Then constitutional amendment procedure. The state legislature plays a secondary role in matters of constitutional amendment. Plays a secondary role. The first role is played by the parliament. The parliament has the utmost power to amend or to ratify. The state legislature, its approval is required for making major amendments in the constitution. There are some provisions in the constitutions for which the approval of the state legislature also is needed. Only in such cases, the state legislature consults and the union parliament, and then amendments are done. So it also plays a role in the constitutional amendment procedure. Electoral functions, that means related to elections. The members of state legislative assembly takes part in the election of the president of India. The president of India is elected by an electoral college, isn't it? You might have discussed this in your previous lessons. You might have read it in your previous chapter. The president of India is elected by an electoral college, and this electoral college consists of elected members of both the houses of parliament and elected members of state legislative assemblies and also union territories like Delhi and Puducherry. So they also perform some electoral functions. They also elect 1/3 members of the legislative council. We have seen now in our previous slide that members of legislative assembly, they elect 1/3 members of the legislative council of the particular state. While the MLA elect the speaker and deputy speaker, the members of legislative council elect a chairman and a deputy chairman from among themselves. So these are certain electoral functions which are performed by the state legislature. And what are the other general functions, miscellaneous functions? The state legislature safeguards the dignity and privileges of its members, which serves as a public forum. It requires the parliament through a resolution for creation or abolition of state legislative council. So it is the state legislature which requires the parliament for creation or abolition of legislative council. And it also acts as a training school for the newly elected members. They learn the political process of India. So here we have discussed the state legislature. We have discussed legislative assembly. We have discussed legislative council. Now let us discuss the state judiciary. State judiciary. That is the third organ of the government, isn't it? We have 3 organs of the government: legislature, executive, and judiciary. Legislature, executive, and judiciary. So judiciary, what is the primary function of judiciary? It dispenses justice. It dispenses justice through what? It dispenses justice through courts. Through courts. So here every state has a high court, and at times when it is not possible, 2 or 3 states share a common high court. Like earlier, after the bifurcation, Telangana and Andhra Pradesh, Both these states were sharing a common high court, which is there at Hyderabad. But now Andhra Pradesh has established its own high court at Amaravati. So two or more states in certain situations can share a common high court. The high court stands at the head of state's judicial administration. That is, it is the principal highest court in the state level. In the state level. Articles 214 to 231 of the Constitution give structure and functions of High Court. Article 214 to 231 of the Constitution, it gives structure and functions of High Court. Appointment of judges. The Chief Justice of High Court is appointed by the President of India in consultation with the Chief Justice of India and Governor of that particular state. The Chief Justice of a High Court, the Chief Justice of a High Court is appointed by the President of India in consultation with the Chief Justice of India and Governor of the state. And because the President is appointing authority, he has the right to transfer these judges from one High Court to another. He has the right to transfer these judges. Telangana High Court here. Telangana High Court. It was founded by the 7th Nizam, that is Mir Usman Ali Khan. And this was initially the High Court for the then state, that is Hyderabad Deccan. But after the State Reorganization Act in 1956, the High Court was renamed as High Court for Andhra Pradesh. But now after bifurcation here again, now we have, it is the High Court for Telangana state. What is the composition of High Court? It has Chief Justice and other judges. It has Chief Justice and other judges. The number of judges is decided according to the size of the state. And they are also appointed by the President from time to time. And here the President also has the authority to appoint ad hoc judges for temporary period, at least for the minimum of 2 years. What are the qualifications? He or she must be a citizen of India, should be in the judicial office for 10 years, to be a High Court judge, and should be an advocate of High Court for 10 years. And what is the age for retirement? It is completing 62 years, or before that, he or she can be removed by a process called impeachment. We'll discuss this in our coming session. Salary and allowances. The Chief Justice of a High Court receives a monthly salary of 2,50,000 and other judges 2,25,000 each. Every judge of a High Court holds the office till he attains the age of 62 years. That is a retirement age of a judge of High Court. The judge can resign by forwarding a letter to the president before the term of his retirement. If a judge wants to come out, he can resign by forwarding a letter to the President of India, because he is the appointing authority for them. What is the method of removal? A judge can be removed by the President only on the grounds of proved misbehavior, or on the grounds of corruption or incapacity to hold his position. Both the houses of parliament should approve this resolution, and the resolution has to be passed by at least 2/3 majority of the members present, and they should give their voting. Then only the judge can be removed. That is, this process is called impeachment. Let us discuss now the powers and functions of High Court. Powers and functions of High Court. It is the power that a court of law exercises to carry out judgments and enforce laws. To carry out judgments and to enforce laws, implement laws in the state. It follows original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, and judicial review. These are the 5 powers of High Court. Now let us discuss these in detail one by one. Original jurisdiction. The High Court possesses original jurisdiction related to laws and orders of state administration related to rules, marriage, divorce, succession, and contempt of court. It has the possess original jurisdiction. That means its decision is final. Under Article 226, the High Court is empowered to issue writs like habeas corpus, mandamus, prohibition, certiorari for the protection of fundamental rights. So under Article 226, it is the High Courts are empowered to issue writs. What are writs now? In my previous session, in my first session, Indian Constitution, I have discussed writs. Writs are the written commands by the court. A written command by the court is called a writ, a written command. Now, we have different writs like habeas corpus, mandamus, prohibition, certiorari. Why are these writs? These writs are necessary for the fundamental protection of our fundamental rights. Now, what is habeas corpus? Habeas corpus, generally a Latin word, means to have a body. That means it is to protect the individual from unlawful detention. From unlawful detention. That means an individual cannot be detained or arrested unless there is a strong evidence against him or her. Mandamus also, it issues orders for a official to perform his duty for which he is bound to, Prohibition, to stop doing from something, prohibit, to stop doing from something. Generally, it directs if the prohibition is a writ which directs the courts. Actually, it is given by a higher court to the lower courts. Certiorari, it is used to deliver a record. It orders the lower courts to deliver a record in its case so that the High Court can review it. The High Court also settle election disputes of parliamentary members and state legislative assembly. It also settles the disputes, election disputes. Now, appellate jurisdiction. Appellate jurisdiction, appeals. The High Court, it hears appeals, petitions from the lower courts in the state and also directly which comes to the High Court. An appeal to the High Court can be made on a decision of a district court. An appeal to the High Court can be made upon the decision of district courts if it is a question of a law. The High Court, it hears 3 types of cases: criminal, civil, and revenue. If death penalty has been given to a convict, then the appeal is made to High Court. If capital punishment, that is death penalty, is given to a convict by a district court, then he or she can make an appeal to the High Court. But in such cases, the district court's judgment is final at times in case of capital punishment. Then the next important function of High Court is revisory function. The High Court is empowered to review any judgment or order made by any subordinate court with a view of removing any mistake or error that might have crept in the judgment or order. This power of High Court is called a revisory jurisdiction. This revisory jurisdiction is done in cases of injustice in the previous cases by the district courts, or some wrong judgments have given earlier. So such cases are, or such judgments are reviewed and the correct judgment is passed by the High Court. So such function of the High Court is called revisory function or revisory jurisdiction. Advisory function: any government department, legislature, or governor may refer or send a case of special importance regarding any law for consideration. This power of High Court to handle such cases is called advisory function. So any government department or governor can send directly a case to the High Court when there is question of law. They want this case to be considered again by the directly by the High Court. So such cases are also heard in the High Court, and such a function of the High Court is called advisory function. One of the most important powers of court is judicial review. Judicial review. What is this judicial review? Judicial review: the High Court has the power to review and declare any law or ordinance ultra vires if it is not in contradiction with Constitution. If it is in contradiction with Constitution, that means any law which is passed by the state legislature, if it is not matching, if it is against the Constitution, then such laws are declared ultra vires. Ultra vires. What is ultra vires? Ultra vires in law is used to describe an act which requires legal authority, but it is done without it. That is called ultra vires. So judicial review is that power of the High Court through which it can declare any law or ordinance invalid if it is not done according to the Constitution. The power to examine the laws and the actions of the local, state, and national governments and to cancel them if they violate the Constitution. Such power of the courts is called judicial review. It is very important in your examination point of view also, students. Then administrative counsel. The High Courts can issue general rules regulating the practices and proceedings of subordinate courts. That means it can control the subordinate courts. The High Courts can control the subordinate courts. It supervises the subordinate courts. It can transfer any case from one court to other court according to Article 228, and also it has the power to decide the judgment of that case itself. Also it can sort out that case. The High Court has the power to investigate or inquire into records or other connected documents of any subordinate courts. That means the High Court also performs supervisory functions. It investigates or inquires into the records of subordinate courts. The High Court has the power to appoint its administrative staff. It has the power to appoint the administrative staff, decide salaries to them. Now, in this session, we have discussed Legislative Assembly, Legislative Council. We have discussed the powers and functions of the state legislature. We have discussed High Court, and we have discussed the powers and functions of High Court. From your examination point of view, all these topics are very, very necessary. So I request all the students to go through the textbook and then make a thorough reading so as to have a good and complete knowledge of the topics which are discussed now. I thank you everyone. I thank the webinar team for giving me this opportunity of conducting the session. Thank you very much.
Shaitaz Begum, it was a wonderful session.
Yes, sir.
Hope the students have got more than the required knowledge, because every citizen, whether educated or uneducated, need to know about the system where they are living. So you gave many details about the state government functioning and all. Thank you very much. So
Thank you,
certainly
sir.
we all look forward for some more sessions from you.
Thank you,
So
sir. Sure.
have a great day.
Thank you, sir.
Thank you.
Okay,
Thank you.
sir. Have a good day. Thank you, sir.